I'm standing here on Pevensey Beach because out here there is a cable which connects the United Kingdom with continental Europe, and it's a cable through which data flows. Data flows from the United Kingdom to the continent, and it flows back again. And it's in this last lecture that I wish to consider the nature of data transfer across borders. And I say that because the United Kingdom is no longer part of the European Union. And therefore we need to think about how that reflects upon the GDPR. And I say that very specifically because the GDPR is about the free flow data and therefore the protection of personal data. And one of the things that we have to be clear about, at least as far as the European Union is concerned, is that the United Kingdom is now a third country. And therefore the GDPR no longer applies to the United Kingdom. So we have to think now of two GDPRs, what's considered as the UK GDPR and the EU GDPR. Regarding the content of the GDPR, the UK has retained the principles and the laws relating to the data controller, the data processor, the data subject. But how we must review UK GDPR is now by referring to the Data Protection Act of 2018 and the Data Protection, Privacy and Electronics Communications, known as the EU Exit Regulations of 2019. This has a great deal, therefore, of importance when we start to think about the transfer of data across the borders. Because we have to think about how data transfers, how it travels through the cables here in Pevensey Bay. And we have to think of it in the view that we have data transfer from the United Kingdom into the EEA. That's the European Economic Order. And the European Economic Order constitutes the EU, Iceland, Liechtenstein and Norway. We also have to think about the transfer of data back from the EEA into the United Kingdom. Beyond that, we then need to think about the transfer of data from the UK to non-EEA countries, and again vice versa, from non-EEA countries into the United Kingdom. So of course now, when we think about data privacy in relationship to data protection, we have to think about the United Kingdom separate from the European Union. The United Kingdom relying upon UK law through the Data Protection Act and through the regulations that it shall create. The European Union, of course, relying still upon the GDPR. But remember that the principles and the laws relating to those members, the data controller, the data processor, the data subject, still are represented. The GDPRs are still the same as far as that is concerned. The issue for us now is to think about how data is transferred. Because the UK being no longer part of the European Union means that data flow is not as automatic as it once was. So the question for us is to say, well, how now can data transfer occur lawfully? And there are mechanisms within the GDPR which allow for such data transfer.
they come generally in four groups, and we're going to look at each of those four groups. The first group is that there is an adequacy decision made by the Commission. The second is for standard contractual clauses. The third is binding corporate rules. And finally, the fourth are the codes of conduct. I first want to consider the nature of the adequacy decisions, because under Article 45 GDPR, the European Commission is allowed to make decisions on countries which have an adequate level of data protection. Now, of course, remember that this adequate level of data protection is the adequacy level within the GDPR itself. But if the Commission makes an adequacy decision on a country, then data can flow freely between the countries without any form of other safeguards. Now, the Commission, in order to do this, first of all, has to have a proposal, gives itself a proposal, to start the adequacy decision investigation. It looks for an opinion from the European Data Protection Board, and it looks for the approval from all other 27 EU countries. And once having investigated the data level protection laws of that country, it will either adopt an adequacy decision or it will not. Now, of course, the effect of an adequacy decision does mean that personal data can flow freely between the country involved and the EU. But in fact, these adequacy decisions extend beyond that, because we talk about the EEA, the European Economic Area. And that extends to Iceland, Liechtenstein and Norway. The European Commission, in fact, have made a number of adequacy decisions on certain countries. The list of these countries is Andorra, Argentina, Canada, the Faroe Islands, Guernsey, Israel, the Isle of Man, Japan, Jersey, New Zealand, Switzerland and Uruguay. All of these countries, data can flow freely back and forth from these countries and the EEA. But of course, remember that now the UK is a third country. In order for it to undertake this free flow of data, it now requires an adequacy decision. The UK has said that they will seek an adequacy decision, but as yet that has not begun. But once and if the UK can receive an adequacy decision, then it will mean that data can flow freely between the United Kingdom and the EEA. It is said that there's one stumbling block, and that stumbling block is an act. It's the Investigatory Powers Act of 2016, and it gives the government a great deal of power to interfere with communications of individuals and organisations. There is a question here whether in fact that act will mean that the European Commission will decide that there is not sufficient level of data protection within the United Kingdom. As far as that is concerned as yet, we don't know. But we are hoping, or the United Kingdom is hoping, that there can be an adequacy decision on the UK. As it turns out, the United Kingdom has already recognised the EEA and in fact a little country called Gibraltar, to have adequate levels of data protection so that data can be transferred from the United Kingdom into the EEA and Gibraltar. Now that's probably not surprising because of course these countries are governed by the EU GDPR. One further thing that has happened with the exit from the European Union now means that in fact the UK will have to have its own adequacy decisions. And in fact the Data Protection, Privacy and Electronics Communication Regulations of 2019 does give the Secretary of State the ability, the power to provide adequacy decisions for data transfer. So we're in a situation right now within the United Kingdom that in fact as an organisation you may transfer data to the EEA and Gibraltar, but because there is no adequacy decision from the European Union, from the Commission, that data cannot be transferred the other way around. It cannot be transferred from the EEA to the United Kingdom. And therefore, there has to be other means by which data transfer can occur backwards, i.e. from the EEA into the UK without an adequacy decision. So without an adequacy decision, we must think about the other means by which data may be transferred. These are known as the restrictive transfer methods, because of course data cannot be transferred freely without an adequacy decision. One of the most important of these methods is the standard contractile clauses. Now, these of course are clauses within the contract. In other words, that organisations who are transferring data between each other have to have a contract in which there are data transfer clauses. That means that these clauses have to provide adequate protection of personal data as it is transferred. Obviously, adequate comes or means within the GDPR. One of the difficulties of these standard contractile clauses is of course their lack of flexibility. But at least we have a range of these clauses which have been agreed by the supervisory authorities of the EEA. In other words, that if you are going to have or use these standard contractile clauses, they are clauses which have been agreed to by the supervisory authority. These are not clauses that you have created in your own right. So therefore, in order for that to occur, you need to be able to look to your supervisory authority to see which of these standard clauses have been agreed. In the United Kingdom, of course, that's the Information Commissioner. Of course, it does mean that having standard clauses, you don't have to negotiate these yourself. And it is by far, therefore, the best means possible so that you can transfer data between organisations. Data, therefore, can be transferred from the United Kingdom into the EA and back again. But if you cannot use these standard contractile clauses, what other means do we have by which data transfer can be lawful? And the next area I want to consider are what's called binding corporate rules, BCRs as they're known. Now these binding corporate rules are pursuant yet again to another, of course, article of the GDPR, Article 46, Paragraph 2, and Article 47 of the GDPR. And they allow for the adoption of these binding rules. In other words, what you are doing as organisations, as corporations, you are agreeing to a set of rules which will show that you are providing adequate protection of personal data as it's being transferred between the organisations. There are a number of things that you have to have within these binding rules. And one of the first is the acceptance of liability. So in other words, if you are breaching these rules, you are therefore liable to the data subject for the breach of those rules. But other things that need to be in these binding rules are how information is to be provided to the data subjects, how are you going to communicate what you're doing, what lawful processing you're doing, how are you going to do that to your data subjects. There needs to be the role of the data protection officer. Where does that fit in within this process? The mechanisms within the group of ensuring compliance with the BCRs. In other words, that you do not have to be just one organisation with these binding rules. You can be a group of organisations with these rules, which allow data transfer between all of you. But of course, there has to be mechanisms in place by which that can be shown to be compliant. Of course, compliant with what? Compliant with the GDPR. Other things are the mechanisms for recording changes to the BCR. In other words, if you're going to change these rules, there must be means by which you can do that. Cooperation with the supervisory authority and reporting, so that there must be a means by which, as a group of organisations being led by these BCRs, that you can communicate with the supervisory authorities throughout the countries in which you are operating. And that means, of course, reporting any breaches of the binding rules that occur. And the final thing that needs to be in this is the data protection training that you are providing to your staff. What's important here is that the group must obtain the supervisory's approval of these binding rules. So as an organisation, as a group of organisations, you just cannot produce these binding rules and therefore act by them or think that you are safely acting within them. They must be agreed to by the supervisory authority. If as a group, of course, you cannot provide these binding rules, or if in fact actually it's difficult for you to do so, there is another means by which data can be transferred lawfully, and that's by codes of conduct. Now, it's said of codes of conduct that these codes of conduct are self-regulatory procedures demonstrating compliance with the EU GDPR. In fact, these codes of conduct are also governed, of course, by the GDPR. Here we're looking to Articles 40, 41, 42 and 43 of the EU GDPR. Just like, of course, BCRs, these codes of conduct have to be agreed to by the supervisory authority. They are clearly less structured than the BCRs, but they do make it possible for organisations to produce their own codes of conduct using the GDPR as its basis, getting the approval of the supervisory authority. And under those circumstances then, the transfer of data will become lawful. And it means that the organisations within the EEA can transfer data to third countries lawfully. The usefulness of these mechanisms
is that it doesn't matter that the country to which you are transferring the data has an adequate level of data protection. You don't need to consider that, and that's not even necessary. The reason being is, of course, that you are providing your own structured form of lawful data protection via different mechanisms, either through your standard contractile clauses, or through your binding rules, or through your codes of conduct.
So where are we so far? We know therefore that if data transfer is going to happen legally between third countries, that is between the EA and a third country, the UK now being a third country, that there has to be some things in place in order that data transfer may occur legally. The best, of course, is the adequacy decision, because as an adequacy decision, it is as if one was still part of the European Union. But if there is not an adequacy decision, as there is not at the moment with the United Kingdom, then we have to look to the other restrictive means of data transfer. And that comes down to those three areas: standard contractile clauses, the binding corporate rules, and the codes of conduct. But there is just one other area which I want to mention, and that's because I've been talking about data transfer as if it's occurring on a regular basis. And for most organisations, of course, that will be the case. But there are exceptions, and there is an exception when the data transfer occurs occasionally, is non-repetitive, and that data transfer is of low risk. If that's the case, then as the data exporter, which is no doubt either the data controller or the data processor, can identify a lawful means by which that data can be transferred, then of course they may do so. The lawfulness comes down to a group of categories, and these are they: that there is express consent from the data subjects, so the data subjects have said, yes, you can easily and readily transfer my data. The second is there's a requirement for the performance of a contract. Quite often, of course, this would be something like an employment contract. That there is a public interest reason for the transfer, that's the third. The fourth is that the need to exercise legal claims, and of course that might be important for a court case within the different countries. The next is that there is a transfer of public register. This is important because the public sector are considered different from the private sector when it comes to the transfer of data. The next is the transfer is in the vital interests of someone incapable of giving their consent. And finally, you can show as an organisation that there are compelling legitimate interests for that data transfer. But remember, this is only data transfer which is occasional, non-regular, is of low risk, and you can find one of those characteristics which say that this data transfer is lawful. One important question, of course, that an organisation who is transferring data has to decide upon is whether in fact they need to make an impact assessment. That is a data protection impact assessment. And that's come about most recently because the adequacy decisions that the EU had with the United States, that is the safe harbour and the privacy shield, have been shown by the European courts to be inadequate. The question I think organisations therefore need to address is, should they, under Article 35 of the GDPR, consider undertaking an impact assessment? The idea of the impact assessment is to see whether in fact there is a high risk
when transferring this data, of breaching personal data, of breaching the rights of the data subject. The impact itself needs to consider a number of things. It should consider the nature, scope, content and purpose of the processing. In other words, what they should be undertaking is a list of things in order to consider whether in fact that data transfer is of high risk. The first thing they need to do is a systematic description of the purpose and envisaged processing operations. That's the first thing. They then need to consider the legitimate interests provided by the controller. In other words, the lawfulness of that processing. They then need to assess the risk to the rights and freedoms of the data subject. And finally, therefore, measures to avoid such risks. If, in fact, an impact assessment is considered or comes to the conclusion that it is a high risk, then the organisation, of course, must involve the supervisory authority. Article 35 EU GDPR actually does give some examples, and it gives these examples here. It says that where the processing is automated and takes decisions concerning the legal effects of data subjects, such as profiling, known as systematic and extensive evaluation of persons' data. That's one example. Another example is when processing special categories of personal data. Of course, we considered in the last lecture the nature of health data, and here clearly this would come under the nature of a possibility of high risk. And finally, of course, of monitoring of public accessible areas. In other words, if there are cameras around, this clearly comes within the possibility of a high risk. It's probably sensible now for organisations who are transferring data to third countries to consider an impact assessment to make sure that they are cleared of potential liability. The final point I want to make here is if, as an organisation, you do not have a branch, an office or established in the European Union, then you have to have an EU representative in those countries in which you are representing or in which you are transferring that data. It depends on the fact of whether you are offering goods and services or if you are monitoring individuals, then you must have an EU representative in those countries if in fact you do not have an office, branch, or you are not established in the EU. One of the difficulties now, of course, within the EU is that there cannot be any longer what's known as a lead authority. In other words, that when I'm talking about the establishment in the EU countries to where you are transferring your data, it could be that you could have identified one of the supervisory authorities in order with which you communicate. Or in fact, if you had to do any reporting, if there was a breach, there was only one authority you had to report to. But the UK, now it is out of the European Union, will have to consider if any reporting needs to be undertaken, it will have to be undertaken to all of the supervisory bodies within the European Union. The UK no longer can have a lead supervisory authority.
So where are we now when we think about the United Kingdom and the GDPR? We have to realise that the United Kingdom has its own GDPR now, called the UK GDPR. But that was based, or still is based, on the Data Protection Act of 2018, altered by the regulations of 2019. But the Act of 2018, of course, was built upon and reflects the GDPR that came from the European Union. and therefore the laws, the principles remain the same. What differs, of course, is now the transfer of information. The transfer that goes across the sea here over to the EEA. There is no problem as far as data transfer is concerned from the United Kingdom onto the EEA, because there is an adequacy decision generated by the Information Commissioner that provides the possibility of data transfer. In other words, it is deemed to be adequate as far as data protection laws are concerned. What differs, of course, is the way that the information comes back from the EEA into the United Kingdom. And remember, there is no adequacy decision here from the European Commission. So therefore, if data transfer is going to occur back and forth from the United Kingdom into the EEA and back again, then there has to be other means by which we can say this is lawful. We know that there are three principal means by which we can do that. We can have contractile clauses. We know that they are sufficient because they have been agreed to by the supervisory authorities, and therefore we can rely upon those in our contracts. There are binding corporate rules. Again, we can rely on those because the supervisory authorities have agreed that they are sufficient for purpose. And finally, the codes of conduct. Also, we can agree upon those, rely upon those, because they have also been agreed by the supervisory authorities. We have to remember, of course, that there are differences between whether you are a public sector or a private sector. The public sector has less restraints upon it because they can communicate with each other, one public sector to another. But if you're a private sector corporation transferring information, then the other thing that's so important is that if you do not have an office branch or you're not established in the countries to which you transfer data, you will need then to have an EU representative who can represent you in those countries. The final thing is, of course, that now the UK is out of the EU, you don't have the opportunity of identifying one supervisor authority which will deal with all of your issues. That is no longer possible for organisations within the United Kingdom. So as a result, you have now to deal with all of those supervisory authorities that you are transferring data to. We therefore have a range of things now we need to consider, not because the GDP is that different from the UK to the European Union, but it's in the transfer of data that becomes the issue. And there we need to consider those range of options to make sure that our data transfer is legal and lawful.